Okay, today we are talking about employment and labor issues, which happens to be Module 8, which happens to be the very last module in the materials. So good job, everybody, making it towards the latter part of this class. Another reminder to get all of your homework in by the end of the semester. Today we're talking about employment labor issues, and I mentioned already that it should be kind of relatable, right? Because most of us are working adults, and so it's a good idea to know a little bit about that environment that that you'll be into. So let's start by thinking about what an employee is. And one way to do that is perhaps to contrast it with what is an independent contractor. Now, in California, there's actually been some interesting law, statutory law and case law around the world of independent contracting lately. So it's good information to have. And I think the reason we've seen some of that law is we've also seen companies attempting to identify their workers as independent contractors. Companies like maybe mobile, like Lyft and Uber, and then maybe companies that deliver things from an app, right? So some of those companies have tried to position themselves as technology companies, and people actually work independently to provide the related service. And whether or not that is an employee or an independent contractor got to be an issue there. So what is an employee? A person who works for and receives payment from an employer. Their working conditions and methods are controlled by the employer. And there's an amount of liability that then adheres to the employer as a result of something we call agency law. Agency is the principle of getting, having responsibility and from your employer to go out and act on behalf of that company. And it's sort of a two-way street, and actually worthy of its own lecture. So I'm just going to leave that behind for a minute. Again, most of us are at some point in our lives familiar with what it is to be an employee, contrasted with an independent contractor. So an independent contractor receives payment from an employer, which is a little different from pay, I suppose. Their working conditions and methods are not controlled by the employer, and the employer is not liable for acts and omissions of that employee. So obviously it's more affordable for the company to be able to designate individuals associated with the company as independent contractors as opposed to employees. They're sort of pro-con on both sides. The agency that cares the most is really the IRS, right? Because there's certain taxes that we pay based on that employment relationship, contributing for the employee towards Social Security and so forth. So the IRS has a test to determine whether or not an employee should be classified as an employee, either exempt or non-exempt, and we'll get into that in a minute, or a independent contractor. I will say one of the interesting things about being an independent contractor, just like being a business person where you own your own business, is that you don't have to be a US citizen to have that title. It's kind of one of those areas where the law doesn't give a lot of straightforward guidance as far as statutory law, but I think it's important here in Southern California to know that there are certain roles or jobs that people can have when they don't otherwise have papers or citizenship or a green card or work permit. Working as an independent contractor or a business owner is one of the things that the IRS or government hasn't been too clear about not being areas that can be worked in by individuals without papers. And I suspect that's because the tax money rolls in, right? They're not real inclined to push that underground. But the government does care what category people fall into. And so they've developed tests to make that determination. And some of the questions that get asked are things like, how much direction and control does the employer exercise over the details of a person's work? Whether the person is engaged in an occupation or business distinct from that of the employer. So I'm an easy example of that. In my first job, even though I was working for well, no, I didn't. I was an employee. But as an attorney, I could have very easily been an independent contractor. Whether the work the person performs is usually done under the employer's direction or without this employer's supervision, who supplies the tools used by the person, the duration of the person's employment, how the person is paid for their work, and the degree and skill required by the worker. So as a general rule, an employer has no legal power to control the details of an independent contractor's performance, and therefore they're not liable for torts committed by the independent contractor, even if committed while working on that contract. So clearly the IRS places a lot of focus on the degree of control that business exercises over the worker to indicate whether or not someone is an employee versus an independent contractor. And just because someone classifies as an independent contractor, that individual is then taking on the responsibility to report their taxes and so forth. Generally speaking, in California, we have this thing and it's called employment at will. I should probably reverse these slides and start with employment at will. But generally speaking, we have what's called an implied employment contract. Or let me back up there. Absence of contrary agreement, an employer may terminate an employee at any time for any reason or for no reason at all without recourse. That is the employment that we all sign up for, unless it's otherwise specified, right? Unless you have some other type of employment contract. And the easiest one to see there's, like, for instance, professional sports, right? Those individuals all obviously have a contract for their work. We hear a lot about that negotiation, but a lot of people work under contract. I work under contract for the college. Every year we sign on to a contract to work for the following year. It's sort of a hybrid, I suppose. But so the default is employment at will, unless you fall into some other category. So what's the payoff there? So just as the employer can fire somebody at will, the employee can leave their job at will. It's a two-way street. You can actually leave your employment the day of, right? Give them a call. Hey, I'm not going to be coming in anymore. There's no legal reason. If you're an at-will employee, i.e. not under any sort of contract, for you not to be able to do that. accept common courtesy and sort of word of mouth, right? So a lot of times you like to take a good reference from one job into another job, and part of that is a certain amount of courtesy, right? So being able to say to somebody, hey, I'm moving on to another opportunity. I'd like to give my 2 weeks notice, or I'd like to give a month's notice. But again, absolutely a courtesy, as the same thing in the, on the opposite side for most employers. We will talk about some restrictions on this, but for now, I just want to, for you to understand generally what employment as at will is. There are sometimes claims that can be made, defamation or emotional distress if the manner in which the discharge is done or the employment relationship more broadly is abusive. And then many states also prohibit terminating an employee for refusing to act illegally or unethically, or for refusing to act contrary to fundamental public policy. When the employee is terminated in violation of law, public policy, or the terms of the employment contract, then they can sue their employer for wrongful discharge. There are also whistleblower statutes that prohibit terminating employees who report illegal or unethical conduct to authorities, to the press, or to their superiors. So again, the starting point is employment at will, but you stretch into some other areas pretty quickly. And the practice of employment law is pretty robust. It's one of those areas where you suspect if you've been mistreated, you can go find an attorney who will at least talk to you and consider your case on a contingency basis, right? Meaning that they only win if they recover for you. There are also in California and most states wage and hour laws. It's not uncommon for employers to not pay someone for the hours worked or for overtime. It's wise as an employee to keep track of your hours and sort of do the math periodically. And people can make a claim for non-payment of wages if that is indicated. There's something called the Fair Labor Standards Act. We call it FLSA. It's a federal law applicable to employers when they are large enough, when they're engaged in interstate commerce, which is almost anybody. Among the provisions are a prohibition on child labor, which interestingly enough, we've seen that in the news lately, haven't we? There were some meat processing facilities, which is among the most dangerous jobs out there. It was in the news that there were underage workers cleaning. And then I think there was some restaurant workers, was it McDonald's maybe, where there were young teenagers, 12 or 13, working. But child labor is illegal. FLSA prohibits children under the age of 14 from most types of work, making exceptions for things like lawn care, newspaper delivery, and entertainment. Anybody have one of those jobs when they were a kid? I delivered newspapers, believe it or not. And I used to have my little pink beach cruiser and put the newspapers. People don't get newspapers delivered. Kids don't do that anymore so much. Adults do it at Oh Dark 100, right, from the car window. But when I was young, it used to be kids, and we would deliver after school. But that was exempt. So let's say I did that in 6th grade. So I'd have probably been about 12 or 13 when I had those jobs. Children age 14 or 15 are allowed to work in non-hazardous occupations. although there are pretty strict limits and limits on the hours. Children's age 16 to 18 do not face such hour and day restrictions, but still may not work in hazardous occupations or do other work detrimental to their health or well-being. I'll take a moment here as a tiny aside and say as well, and I know this is kind of high in the sky for a lot of people, but while you're in college, I'm not a fan of somebody working more than 15 hours a week, at the most 20. I just think if you are a young person, well, I should say I'm not a fan if you're a young person. If you're just starting college or you're, let's say, under 21, 22, I really encourage you to figure out how education works here in California and avail yourself to some of the benefits of, like, for instance, financial aid or Pell Grants and whatnot, to see if you can't not have to work too much while you're in school, because it does make it more difficult to learn. So we also have a woefully minimum wage here in the United States. California goes higher though. Does anybody know what the current minimum wage for California is? If you do, drop it into the chat. So except for so-called exempt employees, like, and we'll talk about exemption in a little bit, the Fair Labor Standards Act requires that any employee who works more than 40 hours a week must be paid overtime wages, and that's at least 1.5 times their regular wage. So when somebody works more than 40 hours a week, they need to be able to make time and a half. What is an exempt employee? An exempt employee is typically the manager or some other professional working in some capacity. That's what I meant to say earlier. When I started my first job, they asked me, do you want to start as an exempt employee or non-exempt salaried employee? And I said, well, I'm a lawyer. I'm probably going to want to be exempt. It probably makes more sense. With regard to layoffs, law requires businesses with over 100 employees to provide 60 days notice to employees before any mass layoff or plant closing if the plant has more than 50 employees. So I tell you that both as future managers and maybe as future employees as well, when you're anticipating layoffs, it's not just one day you're doing fine, the next day you're thinking about layoffs. Usually those things get planned for pretty carefully. A mass layoff is within any 30-day period. There are 500 employees, or 33% of the workforce gets laid off. A layoff means a layoff that exceeds 6 months or a reduction in more than 50% of hours employed each month of any 6-time period. And so those are just some of the definitions in the law. And we will hear about layoffs on TV sometimes when they're large enough. The tech industry has just gone through some pretty major layoffs in different areas, software engineers and so forth. But I'm sure they'll be back. Another important federal law to know about when it comes to employment is this thing we call FEMLA. A lot of times FEMLA actually stands for the Family and Medical Leave Act, and it's a federal law requiring employers with 50 or more employees to provide their employees with up to 12 weeks of family or medical leave during any 12-month period. So if you work for a bigger company, chances are they will be within that circle of companies that need to comply with FEMLA, so that if somebody gets pregnant or they have to care for a family member, maybe a parent, they can take those up to 12 weeks leave. During the leave period, the employer must continue to provide benefits to the employee. However, the employer is not required to pay the employee while on leave. The employer must also guarantee that the worker may return to his or her prior job or to a comparable job unless the employee is a key employee, in which case the employer has a little bit more discretion. FMLA does not apply to employees who have worked for the employer less than 1 year, work less than 25 hours per week for the previous year, or who are key employees. And those employees who are key are the ones that fall within the top 10% of the employer's workforce. So C-level employees generally. Moving on to worker health and safety, there is an agency, we call them OSHA, which stands for the Occupational Safety and Health Administration, and they are empowered to promulgate workplace health and safety standards, to conduct workplace inspections, and to investigate employee complaints. We hear a lot of times they're kind of I don't know. I remember there were memes. I don't want to say the organization's a joke because that's not true at all. They're a very serious organization. But sometimes you'll see memes out there, like in the construction industry, OSHA violation, right? And it's somebody doing something really stupid, like standing on the tip of a ladder, and it's kind of shaking and so forth. But OSHA is a very real part of a lot of jobs. Some jobs, somewhat irrelevant, right? Like me, I've always worked in, well, not always, but professionally, I've always worked in an office. And there's definitely a few OSHA things there as far as, how you set up your desk so that you're comfortable and things like that. Or so you don't strain your back or your wrists. But more important than those industries, I think, are, again, other industries that tend to be a little bit more dangerous: construction, manufacturing, warehouse, and work that goes on outdoors. OSHA will actually come out and inspect work sites, and they'll also hold random inspections, and OSHA will investigate employee complaints. Employees must promptly report any workplace accident as a result of which an employee was killed, or at least 5 employees were hospitalized. So they also keep track of that type of information. Failure to comply with those standards or to report those instances will result in severe fines for the employer and possible imprisonment for culpable supervisory personnel. The deliberate indifference to OSHA standards constitutes a willful violation of federal laws. And that makes sense. I mean, when you imagine it, our work is such a big part of our lives. We are entitled to work in places that take under consideration our safety and our health, right? That don't put us into dangerous positions. For instance, working around pesticides, right? Without proper respiratory cover, different things like that. Because I go as far as to say it's a basic human right. So when individuals do get hurt on the job as well, typically we also will seek redress through something called workers' compensation. Most of us know a little bit about workers' compensation. What's interesting about it is if you think about what it was like before workers' comp, and it gives you a sense of why we do have workers' comp. So if you had gotten injured on a job and that injury caused you to not be able to work any longer, let's say you broke your back or something like that, and you were not thereafter able to do that type of work, you would have to sue your employer to get any assistance. And that happens too much. It's very difficult to sue your employer or to expect people as a matter of policy to do that if they need to recover against the employer. So to sort of take away those responsibilities, we ended up agreeing as a state, and every state has done it, that we're going to instead have a workers' compensation fund. We're going to funnel all those types of lawsuits into a system that benefits employers and employees. And generally speaking, those injuries that are covered by workers' compensation are those that occur accidentally and in the workplace. So that's sort of a little bit about keeping you safe in the workplace and how you can receive different protections. Now I'm going to talk about a little bit of the programs we have, mostly at a federal level, that provide us as well some income security. And these programs are Social Security, Medicare. Some of us have pension plans, and then most states will have unemployment insurance. All states, I want to say, would have unemployment insurance. And combined, these form sort of a safety net for people, right? And this safety net has, it doesn't go, it's controversial, right? There are some people who don't believe there should be a safety net. And then there's some people who are fine with it. These sort of government benefits do occupy a fair amount of our federal and state budgets. But Social Security and different government assured supplemental incomes do help greatly for people who are retired, people who survive the death of somebody close, like maybe a young person loses their parents. Social Security is going to step in and provide them with some benefit. And persons with disabilities, individuals who maybe are never able to work might qualify for what's called SSI, Social Security and supplemental social SSI. I'm forgetting what it stands for. Maybe somebody could Google it for us and pop it in the chat. Supplemental. Anyway, but all give us some security in this world. And then some of us exist outside of some of these systems because we get a pension plan. And actually, I think I qualify for both Social Security and a pension. I'm not yet quite clear on how that works together, but having both been in private industry and now working for the college, it would seem that I have paid into both systems. So some health insurance security comes to us through 2 additional federal programs or laws. One is called COBRA, and that's the federal law extending an employee's right to participate in employer-provided medical, dental, or optical insurance beyond the date of their voluntary or involuntary termination. COBRA generally does not apply to employers with fewer than 20 workers who provide no non-wage benefits to their employees or who completely eliminate non-wage benefits for present employees. There's also HIPAA, or the Health Insurance Portability and Accountability Act. That's a federal law limiting the ability of an employer that provides its employees health insurance to exclude coverage for pre-existing conditions and requiring an employer to decrease the qualifying period for new employees still covered by health insurance provided by a former employer. HIPAA does not require employers to provide health insurance, however, rather it regulates the behavior of those employers who do provide health coverage to their employees. So who really cares about these sorts of laws? People with pre-existing conditions, right? So if you lose your job and you depend on your health insurance because you or somebody in your family has a significant disability or reason to be accessing the health insurance, losing your job or potentially losing your health insurance can be devastating. Losing your insurance for anybody can be devastating, frankly. But COBRA is one attempt to make that more streamlined. We also now have the Affordable Care Act, which is a lot more, really has occupied a lot more of this space, this ability to get insurance on a state market. Provides some of us with some additional protection. I don't know why I don't have an Affordable Care Act slide in here. I probably need it. Okay, so moving on from health, I want to talk to you a little bit about some of the other things that go on in a workplace. Electronic monitoring. The Electronic Communications Privacy Act prohibits intentionally intercepting any wire or electronic communication and intentionally disclosing or using any information so intercepted. There is, however, a business extension exception that tells us that employees may monitor their employees' electronic communications if the employee consents. So usually we do that when we're hired, or if the communication was sent or received via a device furnished by your employer that the employee is using in the ordinary course of an employer's business. So I point this out to say, never assume that your employer is not watching you, even if you are working from home, especially if you're working from home with one of their devices. But sometimes work and personal, as you probably figured out by now, sort of blend together, where you might use, let's say, your own cell phone for work purposes, and because of that, find that there's some, if not monitoring that can be done, definitely the information can be subpoenaed as part of any litigation that might involve your employer. So be careful what you do on computers that you don't want people to know about. And that includes just normal snark about your boss, right? I know we all sort of go to like the real trashy spaces, right? Where you're like thinking, oh yeah, so-and-so is doing this, but even the more benign stuff, right? Where you call your boss an idiot or things like that, these things have a way of coming back at you. So I'm just telling you, as a young person now, if you are a young person, you might want to think about just sort of a policy of, don't do it over email or cell phone or texting or Slack or Teams, whatever it is that you're using, because you'd be surprised what your employer has access to. In fact, I think I've read recently that the use of COVID has resulted in more employers using different types of monitoring softwares, right? I'll even, Rebecca.
I was just going to say, from IT, I've actually been involved with like managing the systems.
Oh, okay.
For access to it.
Rebecca, for some reason, your reception is really bad. Maybe you're in a tricky spot there. But yeah, you know, if you've managed people or managed those systems, as Rebecca was trying to tell us, I imagine she's got some interesting stories related to that. But yeah, just go into the workplace knowing that. So there are some other employee privacy issues that you might want to know about. Drug testing of employees or applicants for evidence of drug use is subject to both state statutory and state and federal constitutional limitations. It may also be prohibited or regulated by the terms of a collective bargaining agreement or even an individual employer's contract. There is a law called the Employee Polygraph Protection Act. Has anybody here ever had to take a polygraph for a job? I've had to do drug testing before, but I've never had to take a polygraph. That law prohibits employees from requiring or causing employees or applicants to take a lie detector test, using, accepting, or referring to the results of any lie detector test taken by an employee or an applicant, and taking or threatening any negative employment-based action as a result. I think for the most part, we don't do lie detector tests anymore. I think they've kind of been revealed themselves to be a pretty hokey science. Maybe that's something too that is more of my generation. But definitely drug testing, especially in those jobs that relate to your abilities, jobs in the medical field, jobs where you drive trucks or other vehicles. You may run into employers who want to do regular or some drug testing. HIV and AIDS testing of employees or applicants are subject to many of the same constraints. In addition, the Americans with Disability Act prohibits a covered employer from discriminating against an employee or applicant because the person has or has tested positive for AIDS. Speaking about employment discrimination, treating employees or job applicants unequally on the basis of race, color, national origin, religion, gender, age, disability, or other characteristic is prohibited by federal law. The federal agency charged with enforcing some of these rights is called the Equal Employment Opportunity Commission, or the EEOC. And other federal statutes and regulations can also apply to prohibiting employment discrimination. One of the interesting aspects to filing a discrimination claim is that the filing party, the injured party, a lot of times has an obligation to do what we call exhaust their administrative remedies, meaning usually you have to go to the EEOC or the California Department of Fair Employment and Housing and exhaust those administrative remedies before you have what's called a right to sue. And they actually, in some instances, issue you what's called a right to sue letter. And then you can go into the courtroom or follow some of those more traditional ways of seeking redress. And this gives the federal and the state agencies an opportunity to investigate a claim, which, because prejudice or discrimination is such a societal issue, right? We all sort of have an interest in limiting discrimination. It allows for our public policy agencies, those agencies, to have some impact on reducing the amount of discrimination. Title VII may also be enforced by private civil actions brought by employees and applicants who believe that an employer has discriminated against them at the end of the day. So there are different types of discrimination. There's something called disparate treatment, which is intentional discrimination by an employer against employees or applicants who are members of a protected class. That idea of being in a protected class is interesting. Protected class may have to do with, let's say, someone's race. To be Hispanic, let's say. It may have to do with someone's gender, to be a woman, for instance, or a person with a disability. In those cases, if you were discriminated against because of that class, you have some redress if you fit into that class. So what's not covered, right? Well, let's say, I was thinning on top. Let's say I was bald. Well, being bald is not a protected class. Let's say I'm not as funny as I think, right? That's not a protected class. You can't sue your employer because as a unfunny person, I got fired. And so that's what it is to be in a protected class. So generally speaking, you have to be aware of what those protected classes are. And there is a lot of political discourse with regard to whether or not somebody belongs in a protected class, or I'm sorry, not whether someone belongs, but whether or not there should be protected classes, right? The idea that some individuals are getting special protections. But be that as it may, we do have them, and they're part of determining or qualifying for this discrimination test. There's also something called disparate impact, and that is those are practices and procedures which, although they're on their face, they're not discriminatory or they're not intentionally discriminatory. They have the effect of discriminating against members of a protected class. And when I think of this, I always think of like certain law enforcement or firefighting jobs, right? Back when I was younger, you had to really be able to do some extreme physical tests, right? Lifting a 200-pound person or something like that. Well, you really don't have to do that in those jobs in any systematic way. But those requirements had the result of keeping a lot of women out of those jobs. So although, on its face, you think, oh, you should be able to pull 200 pounds if you want to be a police officer, because in a desperate situation, you may find yourself doing that. The result of that policy had the effect of meaning you really didn't have female officers or female firefighters. And in that argument's credit, I would say we seem to be doing okay now. They've obviously addressed that issue. So there's something called a 4/5 rule. The EEOC deems a challenge practice or procedure to be discriminatory if it results in members of a protected class being hired, retained, or promoted at a rate less than 4/5 of the rate for the group with the highest corresponding rate. So it really is just a comparison, a more of a statistical comparison. And yeah, so again, a lot of times when the way I've learned about discrimination in the law is that a lot of times you can see it on its face, and a lot of times you can see it in the impact of seemingly undiscriminatory rules. And impact matters, right? Because at the end of the day, you're either participating or not participating fully in these roles that you are for sure paying taxes for. So my personal opinion would be that you have the right to participate in nearly any job. So some of those classes, protected classes, are center on race, color, national origin, and religion. So discriminating on the basis of race or with regard to hiring or promoting employees, employment conditions, or benefits is illegal. What is color or national origin? Discriminating on the basis of color or national origin with regard to hiring or promoting employees is illegal unless the discriminatory policies or procedures have a substantial, demonstrable relationship to realistic qualifications for the job in question. Discriminating against employees on the basis of color or national origin with regard to employment condition or benefits is also illegal. And then last, employers are required to reasonably accommodate their employees' religious beliefs, unless doing so would cause undue hardship on the employee's business. An employee's religious beliefs need not be based on the tenets or dogma of a particular church, sect, or denomination, as long as it is sincere. So moving on or further into this this debate, let's learn about types of sexual harassment that exist. Granting employees job promotions or other benefits in return for sexual favors, or referring or threatening refusal to hire, promote, or extend other employee benefits is sexual behavior, if sexual favors are refused, is called quid pro quo harassment. You do this, I'll do that, right? You go on a date with me, I will give you the promotion. There's also hostile working environments that is working in an environment where the language or conduct is so sexually offensive that it creates an extremely hostile working environment. It doesn't matter if the perpetrator and the victim are the same gender, by the way. I want to talk a little bit about online harassment. Sending sexually offensive emails and viewing sexually explicit or offensive internet sites on workplace computers may create a hostile working environment. Employers seeking to prevent online harassment must delicately tread the line between, on the one hand, allowing workplace harassment to go unchecked, and on the other hand, invading employees' privacy rights in order to determine whether they are using workplace computers to send or view sexually offensive material. I will tell you, as somebody in her 50s, right, I came of age really when the internet was just beginning, and there were a lot of people that were occupied at work, not necessarily doing work, you know, and yeah, so, you know, this was maybe a time and a place sort of situation, but that it was, I think, really mind-blowing for a lot of men that you know, the internet became so you know, pornographic, for lack of better words. Oh, my little slide here is a little off. So sexism, federal law prohibits employers from discriminating against applicants and employees on the basis of gender, classifying jobs as male or female, right? And this one can kind of, I don't know, because could anybody come up with a job that they would view as being strictly male or female? I'd like to hear your opinion about that. Because my brain, I don't know that I can necessarily come up with any, but are there any jobs where you would have to be male or female? Like my mom has a caretaker, and she has a female caretaker, but she also has one male caretaker. And I would think, oh, I could see, and it really doesn't bother her either way. It's interesting. But are there jobs that should be just reserved for one sex? I don't know. I think there are jobs that, practically speaking, sometimes fall into that category, but federal law prohibits employees from discriminating on the basis of gender, advertising jobs in help wanted columns designed as male or female, unless the employer can prove that the gender is essential. Okay, so I thought of one. It's right here on the screen. Male actors or female actors, right? You need to cast a male role. Then it would be logical that you would need to restrict that role. I don't know, to how we've come so far. Would you have to be male, or would you have to present as male? Do you have a thought, Kimberly?
Yeah, I do. And again, showing my age, I'm thinking of Yentl when she dressed up as a man for so long,
Right.
and then there are other, I'm not sure it's medieval times, but I mean, Joan of Arc, and there just are all these females that portrayed themselves as males for such a long time before they were discovered.
Actually, if anybody were to do ever take like a queer studies class or women's studies or whatnot, the history, there are a lot more instances of people. Generally, I think it's easier for women to portray themselves as men than vice versa, but women serving in the military, like in the Revolutionary War, or in different roles, and as another gender. I don't think that is a new phenomenon, for sure. But anyway, we digress. It's interesting. We digressed. But yeah, and it's so funny too, because as I'm reading through some of these laws, I'm thinking, in some respect, they're almost, I don't want to say antiquated, but like, for instance, we don't call them want ads anymore, right? I got my first real job out of a newspaper. Like, I actually was reading the back of the newspaper and saw the job and applied for it and got it. That's really not done anymore. Most of the time people are looking on the internet, although they do still advertise jobs in the newspaper, I've noticed. But anyway, so sometimes there are certain aspects of this that I think might be a little outdated. Yeah, Rebecca, what do you think?
Not sure if my microphone's gonna work.
It's better.
Like my husband's company, for instance, he works for an international security company, and they have very openly known policy that they will not hire women for field tech positions. And it's actually, in their opinion, a security issue, because they've actually had women who did work in those positions get like locked in utility closets and stuff with men. So to them, it is liability, and they literally will not hire.
So, depending on how well known that is, that's a liability right there. You say security, you mean like security, right?
Security system. So like, he okay. Access control, where like there's you have to punch a number to get into a room, or security cameras that are in like large buildings, commercial buildings. So they're major projects. He might be underground, he might be crawling through attics, kind of thing.
Gotcha. Yeah, I suspect that they need to reevaluate their policy. There might be some exposure there to if it's a well-known policy.
Although one of my really, really good friends was a Secret Service agent. Woman.
There you go. Okay.
And, so each industry is a little bit different, but there isn't. I don't think there's a ceiling for us.
There are definitely bona fide occupational rationales for certain things. For instance, let's say you're the Secret Service agent who was in charge of watching the Obama's 2 young daughters. I'm going to suspect there was probably always a female on that duty, you know, and looking at that as likely a bona fide occupational requirement. I think the problem a lot of times is people allow their biases to influence what they think of as a bona fide occupational requirement. And then also, you know, remember too, bad things happen to men as well, right? If women are vulnerable, men can be vulnerable as well. And look for actual data to support your position, either way.
So Professor, did you see that there was recently, I think out of Florida, a principal that was talking about encouraging to have male coaches, like PE coaches, involved with biological females, I guess, being in their dressing room? And the principal was actually talking about how it shouldn't matter if these adult males were with these girls. I don't want to elaborate too much on it because I don't want to get into politics there, but I'm wondering if that might be an example of like the requirement to have a specific gender for a job, or if we're going past that even.
It is Florida. I think you have to point out, but also, yeah, I think it's fair to say, you know, someone who has a supervisory role in a sports program should probably be and by I say supervisory, I mean where they would enter a gym area, they would need to be the same gender as those players. But I also think that there are reasonable ways to get around some of that. So I went through basic training in the Army, and we had male drill sergeants. You know, there were 50 women in the barracks, and we had male drill sergeants. But they would literally yell "male on the floor" when they came in, and you put on, you know, if you weren't already dressed, you put on your PTs. You know, I think a lot of times we confuse custom with a requirement, right? And that's, I think, what's meant by, you know, what is actually required, what is a bona fide occupational requirement. I you know, as a runner in high school, I had male coaches. Now, of course, they weren't coming into the locker rooms, but you know, to use that as sort of a blanket restriction, or it probably doesn't hold up when under analysis, right? But yeah, no, I would, and I went too far afield on that, Rebecca. Did you want to add?
Thank you for going into that. No, but you know.
Oh, sorry, you're cutting away again. Either way, I remember getting into a debate in law school, because you know, you may not realize it, but you're not allowed technically under the law to advertise for a male or female roommate, right? And I've had the occasion to advertise for a roommate in my life, and you're not, the law says you can't say male or female. And I remember my law professor saying that was just absurd. You know, if you were a young woman in college and you needed a roommate, you should be able to advertise for another young woman. And, you know, and his justification for that was, you know, it's just a matter of safety. And I said, but, you know, does it really keep you safer? You know, a lot of women come with boyfriends or, you know, men in their lives that are dangerous. I think it's a sort of a false sense of security. Plus, upon meeting people, you may find it doesn't really matter. But anyway, yeah, I mean, it's a long, people have all sorts of positions on it, for sure. But moving on, sources of sexual harassment. It's not just your supervisors. Sometimes it can also be coworkers. And there's a video here. It's a 10-minute video, but I'm going to let you watch it on your own. It came, so supervisors, employers are generally liable for sexual harassment by supervisors, regardless of whether the employer knew of the harassment or the employee suffered any adverse job consequences. To hold an employer liable for a supervisor's sexual harassment, the employee must prove that the supervisor took a tangible employment action, that is, firing or failing to promote against the employee. The employer can avoid liability for supervisory harassment by proving that they, one, have taken reasonable care to prevent or correct promptly any sexually harassing behavior, and two, the employee suing for harassment unreasonably failed to follow these policies and procedures. So there's a little bit on sources of sexual harassment. Let me teach you about something called constructive discharge. It occurs when an employer causes an employee's working conditions to be so intolerable that a reasonable person in the employee's position would feel compelled to quit. So what happens when you quit a job versus when you're fired from a job? If you're fired from a job, you typically get some sort of unemployment insurance. So there are times when people's workplaces are made so intolerable that they quit. But later on, reflecting on that, they might have a case for constructive discharge, which would then make them eligible for that unemployment insurance, because the employer was behaving in such a intolerable way. The working conditions were intolerable. The employer knew or had reason to know they existed, but failed to correct them within a reasonable time. And in many cases, the employer's discriminatory policies or practices caused the intolerable conditions or made the employee's resignation reasonably foreseeable. So that's called constructive discharge. So don't always assume if you are out of a job that you left, that always cuts you off from any sort of benefit. If you left because the job was intolerable, in one of those ways that we've talked about a little bit, consult with an attorney. You may have a case for constructive discharge. Age discrimination in employment is prohibited. Employment discrimination on the basis of age against persons 40 years of age and older, and a mandatory retirement for non-managerial employees. Both of those things are prohibited. So age discrimination. Age discrimination, by the way, you might be surprised to learn, is one of the areas where we kind of tend to look the other way as a society. It's one of the areas of discrimination that tends to offend people the least. And we might want to ask ourselves why that is. If we truly have a society where everybody gets to participate, we might sort of challenge some of our assumptions and ask about age discrimination. I'm getting close to the end here. I want to recommend in the materials, there are some links to some videos having to do with disability discrimination. Let's see if this will play. Actually, I don't think it's very long. Sorry. Let us preview. Oh, yeah. It's only going to be 2 minutes. But it's good.
There was a belief that if you had a disability, you didn't have any desire to live a life. You didn't have the goals and the dreams that somebody non-disabled had.
When people ask me how I got involved in this, I say, well, it was easy. I got committed to a mental hospital. And as soon as that happened to me, I had this very powerful conviction that something was fundamentally wrong.
I think that particularly in Willowbrook, that we have a situation that borders on a state cat.
They're stuck there and they didn't belong there. They didn't want to be there. And we wanted them free. Close them all. Don't fix them.
Sticking that microphone into Eddie's mouth while he's laying in his iron lung, it's like blew people's minds. Sometimes, in order to get somebody's attention, you have to hit him across the head with a 2x4. And Eddie was the 2x4 of the community.
Now, those of us in Berkeley, when you talk demonstration to Berkeleyites, I mean, we knew how to organize the protest.
It's the first really militant thing that disabled people have ever done. And we want people to listen to us.
We had a vision. We expected to change the world. We had a compelling need and we had a compelling story. You know, if you have a good story, it's not hard to get people to watch it or listen to it.
They chained all the wheelchairs together. Some people chained their bodies to each other. The police were just, they were just going berserk. They didn't know what to do. It was great.
Let the shameful wall of exclusion finally come tumbling down.
Having been told for so long how powerless we were, and here we were with the President of the United States signing this document that was our Emancipation Proclamation.
The development of true discrimination takes decades and centuries. I don't believe that discrimination easily ends just because we've been able to get pieces of legislation passed.
That woman who was just speaking to, she just passed away. I read her obituary. She was a towering figure in the disability rights movement. But anyway, yeah, this documentary, it's called Lives Worth Living. And if you have an interest in discrimination law or and so forth, you might check it out. It's on PBS, it looks like. There's also another really good one on Netflix called Crip Camp. And it's a reference to a camp that a lot of kids would go to and how that opportunity did so much for them. I've always found it really interesting because my grandmother had polio. So those people in the iron lungs, she never had to do that, but she always walked with braces on her feet. She didn't have the use of her lower body. So I was always, I don't know, I was somewhat impacted by the passage of the Americans with Disability Act because, you know, it meant a lot to my grandmother. Anyway, and remember in this class, I do give you points for sort of going outside the curriculum and perhaps watching those documentaries. You just have to pop them into that discussion board and I'll give you credit for that. So disability, I would also add about disability. It's the one thing that cuts across all groups and all other ways that we tend to distance ourselves from other people. Like, oh, you know, disability doesn't limit itself to any particular race or gender or wealth or anything else, really, intelligence. So because of that, it's one of the more unique legal issues to think about. Also, philosophical ones, if you think about these things in your life, because there is a reasonable possibility that every one of us will experience disability at some point in our life. Fortunately, for some of us, hopefully it happens when we're very old, but there's no guarantee. And so, it's one of those areas where you go, oh, I'm glad the law is there. Or, maybe you think a little bit more about it. But we do have the Americans with Disability Act, and it prohibits private employers from discrimination in hiring, promotion, and discharge against persons with disabilities. I'll say as well that there are some parts of these laws that do pertain either the ADA or another law called IDEA that will pertain to individuals in academic settings, right? So a lot of students have these protections in their student experience. And so if you were to identify as having a disability and you needed assistance with that, we have what's called DSPS on campus, and they help individuals sort of navigate how are we going to accommodate that disability. So what is a disability? A mental or a physical impairment that substantially limits one or more major life activities. Prior to 2008, courts held that correctable conditions such as needing to wear glasses, diabetes, or epilepsy, or repetitive stress injuries were not disabilities under the ADA. And so this is a good example. So Congress disagreed with the court, right? Congress said, no, it is a disability. And in 2008, Congress amended the ADA to state that employers may not consider mitigating measures or medications when determining if a disability exists. So, even though you wear glasses, your vision can still be a disability. Whether or not it actually impacts your job is another question. But like I said, most of us could probably qualify as having some disability. It's a very normal part of life. It's part of the human condition, right? And fortunately, most disabilities are pretty easy to accommodate. The employer's obligation is to what's called reasonable accommodation. If an otherwise qualified disabled job applicant or employee can, with reasonable accommodation, perform essential job functions, the employer must make accommodations. So if you find yourself ever in a situation where something is keeping you from doing your job and it can be easily accommodated, and it's a disability, know that you have some protections there. So there are some defenses that your employer can bring up. It's a business necessity. The discrimination policy or practice is related to job performance. Bona fide occupational qualifications, right? Such as when identifiable characteristics are reasonably necessary to the normal operation of a job or a business. Men's swimwear company may hire only male models, for instance, or seniority. The employer has in place a system in which those who have worked longest for the company are first in line for promotions, raises, and other benefits, and those with less seniority are the first to be laid off. So it could be that seniority is the reason that someone is let go and it doesn't relate to a disability. Employers may also limit their liability for discriminatory acts by presenting evidence of misconduct by the employee alleging discrimination. So I want to talk a tiny bit about affirmative action. Affirmative action is the hiring and promotion policies that give special consideration to members of protected classes in an effort to overcome present effects or past discrimination. And I will tell you that white women in general have probably been the greatest benefiters, if that's a word, receive the greatest benefit from affirmative action programs. People tend to look at them nowadays. It's sort of, for some people, it's sort of a bad word. But I would disagree. In fact, the picture on the screen is me at probably 21 years of age. And the reason I joined the military as an Army reservist is because I saw a magazine ad in Self. And it was a young woman who needed money for college. And I thought to myself, hey, I could use that to pay for school, right? It didn't occur to me that it was an option. But that was affirmative action. And it, I will acknowledge that it played a big role in my life and allowing me to go finish my undergrad degree. And even I was still getting the GI Bill when I was in law school. So was a huge benefit. And consequently, I find myself agreeing that they are, that affirmative action is good. Again, other people may disagree. But I think that representation matters personally. And if we take affirmative steps to attracting certain groups to places that they are underrepresented, so be it. That's affirmative action. But again, others may disagree, and that's perfectly fine. I want to talk a little bit about immigration. So there are a couple of immigration law has been woefully not updated in a very long time. But there's a law called the Immigration Reform and Control Act. It prohibits hiring individuals who are not citizens or lawful permanent residents. Employers bear the responsibility for compliance in this area. And I think that the justification for that is really sort of very humanistic, in a sense of every individual will go out and seek to survive, right? We've now got people at our border. These are really just people seeking to survive, seeking jobs. And so the onus is really on the employers, and it really should be on the governments to figure out solutions that work, other than name calling, in my view. But employers are required to ascertain whether or not an employee is lawfully employed. And then again, it seems like we're pretty woefully unable to amend our immigration law in any meaningful way. We've really gotten ourselves into a hole. I think the last time we had meaningful immigration reform was probably in the 80s under Reagan, which is why some of you may have parents who revere Reagan. But we also had some immigration reform under Newt Gingrich and Bill Clinton, although I think that it was not nearly as beneficial as amnesty under Reagan. So there, I'm going to give you just sort of a hodgepodge of some other federal labor laws. Employees have the right to peacefully strike, picket, and boycott. Employees have a right to bargain and to strike to protect that right. And there are certain unfair labor practices that are prohibited. Things like interfering with employees' rights to organize, discriminating against employees based on union membership, and refusing to bargain collectively. So we have labor is becoming much more of a force. I think we're probably entering a period where labor is getting stronger. So it's interesting to know a little bit about unionizing. If a majority of employees sign authorization cards stating their desire to unionize, union supporters may seek formal recognition from their employer. If the employer refuses to formally recognize the employee's desire to unionize, they may petition the NLRB for an election. And we've seen this in real time with companies like Starbucks and Amazon and so forth. And in any case, employer will have to bargain with the union over severance benefits. Oh, excuse me. So collective bargaining is what takes place when a union has been voted in. And that means that the union is bargaining collectively on behalf of all these employees for things like pay and benefits and protections with regard to severance and so forth. Both parties are obligated to bargain in good faith. A failure to bargain in good faith constitutes an unfair labor practice, and it can result in sanctions against that company. And then ending with striking. So a strike is when unionized workers leave their jobs and refuse to work, typically accompanied by picketing. We're seeing that now. Who's striking now? Oh, I'm sorry. I'm thinking of the writer strike in LA. I knew somebody was out there picketing. We've seen it on the news. We've seen that play out. So there's lots of other unfair labor practices, too many for me to really go into them now, but things like secondary boycotts or locking employers out. So I know I threw a lot at you with regard to different sorts of employment, but that's what's on the menu for this week in the materials. And that's what I have for you today. What I want to remind you about as well is that we are now at the end of the class. So the time has come. If you've been putting off any homework, make sure you get that submitted. Because I want to give you all A's in this class. But as for me, let me go ahead and stop recording. And well, we will meet next week, but really only to talk over any of the work that you may have remaining if you need anything from me. Otherwise, really focus on just getting all your work done.